This video will discuss the landmark U.S. Supreme Court case of Riley v. California from 2014, a World Affairs Council of Austin mock trial focusing on the Fourth Amendment and digital privacy. Riley v. California originated in the San Diego County Superior Court between 2009 and 2010. It was a state criminal prosecution concerning a warrantless cell phone search incident to arrest. The case involved David Leon Riley, who was arrested, and officers seized his smartphone. They searched the phone without a warrant, using the digital evidence to link him to a gang-related shooting. This was the trial-level case before the Supreme Court ruled on required warrants for phone searches. Riley was stopped for expired tags, and police found concealed firearms. After his arrest, officers searched his smartphone without a warrant, revealing photos, videos, and text messages related to gang activity and a drive-by shooting. This raised the conflict between traditional search incident-to-arrest doctrine and the privacy of smartphones. In 2012, Riley was arrested after a traffic stop led to the discovery of a loaded handgun. His locked iPhone 4S was seized and forensically examined without a warrant. The key question was whether a warrant was required for this comprehensive search of private data. Riley moved to suppress the phone evidence, arguing a Fourth Amendment violation. The trial court denied the motion, and Riley was convicted. After the California Court of Appeal affirmed, Riley appealed his case to the U.S. Supreme Court. We will now examine the core arguments and key witnesses presented by both sides in Riley v. California. The defense argued that a smartphone's vast personal data is protected by the Fourth Amendment, violating Riley's rights. They asserted that the phone posed no physical threat, and the evidence, therefore, should be suppressed. Riley's key arguments centered on the vast amount of private data on a smartphone, which should not be subject to a warrantless search. He argued that digital data poses no physical threat and must be suppressed due to the unconstitutional search. Carlos Mendoza, Apple's privacy lead, filed an influential amicus brief, arguing for strict privacy protections for data and emphasizing the requirement of a search warrant for phones. David Leon Riley was the defendant. His initial arrest led to a warrantless search of his seized smartphone, which uncovered incriminating gang evidence, leading to charges of attempted murder. Dr. Ryan Baker, a constitutional law expert, provided an analysis supporting Riley's Fourth Amendment privacy claim, addressing the challenge new digital technology poses to existing law. Next, we will review the arguments and witnesses presented by the state of California, the prosecution. The prosecution argued that the search was valid under the existing search incident-to-arrest precedent to ensure officer safety. They stressed that digital data is vulnerable to remote destruction, and the phone contained evidence of violent criminal acts. California's theory was that the search was reasonable and valid under the search incident-to-arrest exception, necessary to preserve evidence that could be easily destroyed or encrypted. Detective Michael Torres, the lead investigating officer, conducted the warrantless phone search incident to the arrest. He testified that the search uncovered evidence linking Riley to gang activities and shooting crimes. Dr. Maya Patel, a digital forensics expert, testified for the prosecution on data extraction and the risk of data loss. Her testimony provided a technical justification for the quick search, though the defense suggested alternatives for evidence preservation. Dr. Patel's testimony authenticated the text messages and gang videos retrieved from Riley's phone. She detailed the forensic extraction of the seized digital evidence. The district court ruled that the warrantless search of Riley's iPhone violated the Fourth Amendment. The court reasoned that a smartphone's vast data requires a warrant, setting the stage for the Supreme Court review. The California Court of Appeal upheld the trial court's denial of the suppression motion, affirming the initial conviction. They ruled that the search incident-to-arrest precedent applied to the seized phone. In 2014, the Supreme Court unanimously reversed the lower court decision. The court ruled that police must obtain a warrant to search a seized cell phone due to the vast scope of digital data. The Supreme Court reasoned that the vast scope of digital data warrants greater protection. Cell phones are not a physical threat, making the search incident-to-arrest exception inapplicable to them. The key takeaway is that the Supreme Court established a warrant requirement for searching a seized cell phone. The search incident-to-arrest exception does not apply to digital devices due to the increased Fourth Amendment privacy protection required for digital data. The constitutional legacy of Riley significantly expanded Fourth Amendment protection, setting a new precedent for technology and criminal law and recognizing the profound privacy implications of digital data. This concludes our video on Riley v. California. Thank you for watching.